Okay, welcome to this week's class lecture. We're going to talk a little bit this week about some of the major anti-discrimination employment pieces of legislation that are out there. And as much as I think I can do a great job and get through this, I really needed to call in some experts and some friends here and phone a friend. So I'm really pleased and honored that I have one of my colleagues joining me today who's an industry expert, a legal expert in the field, and a longtime friend. So Dr. Robert McDonald. And Rob, I'll ask if you wouldn't mind just doing a brief introduction of yourself.
Yeah, Dr. Robert McDonald. I've been practicing law for the past couple of decades, done a lot of labor and employment stuff. In addition to that, I've got my PhD and my MBA, and I teach a lot of law-related courses, a lot of law and business-related courses at the undergraduate, graduate, and doctoral level. So review these materials quite often, kind of follow what's going on out there in industry, and kind of do a lot of reviewing this stuff. So I'll try to do my best to make it as interesting and as informative as I can.
Awesome. Thanks so much, Rob. I really appreciate it. So what we're going to cover today, we're going to walk through some of the major pieces of anti-discrimination legislation that employers are subjected to today. Naturally, there are dozens and dozens of different pieces of legislation. So Rob and I really tried to focus in on a few that we really felt were very critical for you as students and HR professionals to make sure that you had a keen understanding of as you walk away from this course. The second thing is most of these pieces of legislation at the federal level do fall within the purview of the Equal Opportunity Employment Commission from a governance perspective. So I've asked Rob to talk a little bit about what the EEOC is and sort of what happens whenever there is a potential violation or alleged charge that takes place against an employer, but also how you as individuals or HR professionals or managers might be able to leverage the EEOC in ways that you haven't necessarily considered in the past. And then finally, we'll give you some compliance recommendations as well. So with that, these are the four pieces of legislation that we're going to walk through briefly here today. First, the Title VII of the Civil Rights Act of 1964, the Pregnancy Discrimination Act of 78, the Age Discrimination in Employment Act, and finally, the Americans with Disabilities Act. So really the hallmark statute of, I think, all anti-discrimination laws, Rob, as from everything I've ever learned, is really Title VII. And I thought maybe that would be a good place for us to start and hear your thoughts on that piece of legislation.
Yeah, thanks. And I think that is kind of the beginning of this when you talk about the Civil Rights Act of 1964. I also want to point out that many states and local governments also pass a lot of laws that mirror some of the things that we're going to talk about. And sometimes the numbers may be much lower. So for example, in Title VII, you need 15 employees. States may have laws that say you need 4 or 2, or in some cases even 1 on some of these laws. So we're kind of really looking at the big picture as we talk about this. And you and I both know there's dozens of other laws that we could have included, but we kind of narrowed it down to this just to make it somewhat manageable. But when you talk about Title VII, when it was passed, historically, if you look in the legislative history, some of these terms were included in there in at least an effort to sort of thwart this legislation. The feeling was there's no way they'll pass this, it's incredibly broad, and it did pass. And what Title VII did, it created what are called protected classes. So, can you discriminate against people for certain things? I'm an avid sports fan. Could I discriminate against someone who likes a particular hockey team that maybe I don't like? Well, maybe legally I could, it would be discrimination, but it's not actionable discrimination. But what we see with the development of Title VII is things that are now actionable. So these are often called the Big Five. When we talk about sex, race, color, national origin, and religion, all those things are formally protected by the government. So you cannot discriminate on that basis. Now, when we talk about discrimination, it can come in a couple of different forms. And sometimes it's intentional. And if you hear the term disparate treatment, I'm saying I will never hire someone because they're a woman, or I will never hire someone because of their particular religion. There's nothing accidental about it. That most likely is going to be a violation of Title VII. And if it's intentional, the penalties may be a little bit more significant. And I think that makes sense because we want to punish that kind of behavior in most instances. So if it's intentional discrimination, there may be the opportunity for punitive damages. The amount may be more significant when we talk about damages. But it also can happen in the accidental sense, where I say, I will never hire anyone who's under 6 feet tall or under 200 pounds. Now, there are women who would be over 6 feet tall and over 200 pounds, but I think women would be disproportionately affected by those rules. So if you can't show that those requirements are absolutely necessary for a job, and that's called a bona fide occupational qualification. Courts don't like bona fide occupational qualifications because they render people unemployable. So it must be absolutely necessary. But a big part of, I think, what we have to think about in Title VII when these categories get created, it's the historical perspective. We're coming out of World War II, society's changed, the baby boomers are being born, society's getting younger, women enter the workplace, civil rights movements in full effect. So what we see in the 60s, 70s, 80s, and 90s, you kind of see this building of these protected classes. But Title VII definitely was the first. When we talk about in 1964, what happened.
Rob, one of the questions I had for you was, so we talk about sex being one of the protected classes here. Would sexual harassment, although it's not discriminatory in the typical sense, would that fall under protection under Title VII as well?
It does, and sexual harassment can come in a couple of different forms. One is called quid pro quo, which is this for that in Latin, and those cases are a little easier to prove. So for example, if a supervisor says, if you go out on a date with me, I'll consider you for the promotion, that is a quid pro quo relationship. Now, scarily, there's a couple of cases that have said even a consensual relationship in the workplace can be actionable. So I jokingly tell my students, date your boss, but don't date a subordinate, because even if you think it's a boyfriend-girlfriend situation or consensual relationship, it may be actionable, because some courts have said, look, you say you're dating, but how do I know that person didn't feel threatened or they couldn't end the relationship? So it can be very dangerous for employers. Another form of harassment is the hostile work environment. So if people are telling inappropriate jokes, using inappropriate language, showing pictures they shouldn't be showing, that can create a hostile work environment that might also be actionable against employers. There also is a thing that can kind of fall under a category of sexual harassment called gender stereotyping. And there's a few famous cases with respect to that, where employees were told, for example, there's a famous case in the Price Waterhouse case where a woman was told she was too mannish when trying to be a partner in an accounting firm. There's a real case where a female employee was pregnant. She was going to have a baby. She was on the verge of tenure. And the employer was telling her things like, well, if you were really a good mom and you really cared about your kid, you wouldn't be here working. You'd be home taking care of your child. Those are gender stereotyping cases, and they are actionable. So you would be shocked at sometimes the things that employers do. But clearly, if you're treating someone different because of their gender, their sex, there can be some potential liability there. At one point in time, about 20 years ago, there was a disparity between the circuits too, about whether same-sex sexual harassment was actionable. There's a case called Uncale versus Sundowner Offshore Systems that the United States Supreme Court heard, and it is actionable. So men can sue men, men can sue women, women can sue men, women can sue women. I always tell students, I live by this acronym COD. Consistency, objectivity, documentation. Treat everybody the same. Everything's above board. You're constant in the way you treat people and make decisions. Everything's done on an objective basis, and you document what you do. Because as humans, I think we overestimate our memory, and someone tells us something, and it's 3 months, 6 months, 9 months later, and we don't really remember exactly what they said, and that can create some problems.
I think that's great advice, and that's a great acronym for us, students and professionals, COD. I think that's really important to remember.
Yeah, and the memory part, I think when people get confused, I'll just say, like, what did you have for lunch yesterday? And it's a deer in the headlights. We don't remember things.
That's exactly right, 100%. Rob, the next one I thought we would talk a little bit about is kind of an offshoot here, and I'm sure you'll touch briefly on that, but the Pregnancy Discrimination Act, and what was going on and what drove this piece of legislation?
Yeah, again, I think this is part of the sociological change. And I always say, if you watch television show from the 40s and 50s and that era, it's always shocking to me, these gender stereotypes that were taking place at that point in time. And I don't think that was a true reflection of most people's world and society at that point in time. But clearly in the 1960s with the civil rights movement, the government said you can't treat someone different because they're pregnant. So Title VII was amended and we talk about pregnancy discrimination. And now, again, it doesn't give people more rights, but it just protects people from discrimination on that. And we talk about pregnancy discrimination. It can be childbirth, it can be pregnancy, it can be any sort of related medical condition. But I think for most employers, the important thing is to treat pregnancy like any other medical condition. And when I say be consistent and objective and document, I think where employers get confused, they think pregnancy is something unique and different. And believe me, I know children are great and pregnancy is great. But what I'm saying is, if someone says I can't work because I have a medical condition, to me, it doesn't matter if it's a heart problem, a back problem, pregnancy. What you care about is, can the person perform the job or not? And if they can perform the job and their physician says they can perform the job, you have to let them perform their job. It's not up to you to pretend you're an MD as a business person. And there's a famous case called Johnson Controls, where the company decided to protect the employee and protect the fetus. The employee was going to be working with dangerous chemicals. The employer was concerned that if something happened and the baby was born and there were any kind of problems, the employer would be liable. So the employer decided to step in and not allow the employee to work. And you can't do that. If you're treating them different because they're pregnant, that is prima facie pregnancy discrimination. I mean, courts have said you're going to pay for that. The question's going to be how many zeros will be at the end of that check. So I don't think you can substitute your judgment for an MD, but as a practical pointer, I tell people, if you do have those concerns, I would certainly want to disclose every chemical that person was going to be working with. I would want them to clearly assess all the dangers. I wouldn't want them to come back and say, I didn't know. So I would spell that out, make sure they had the appropriate safety gear, all those kind of things. But again, if someone can perform the job, you have to let them perform it. And with pregnancy, you've got to make the accommodations if you can. But what you can't do is say, I'm going to let the guy off because he's got a back problem. Again, temporary disability. I'll make the accommodation for the guy, but I'm not going to do it for the woman who's pregnant. That's what's going to create liability for the employer.
And Rob, whether it's this law or any of these anti-discrimination laws that we're talking about today, are there different rules for applicants for jobs versus active employees?
Yeah, it definitely changes. The relationship changes. And when you talk about a pre-employment inquiry, I think that the need to know is a little bit less at that point in time. And again, I think if you don't need to know, you don't ask. What I really care about is, if I need you to be at my place of employment Monday through Friday from 8 to 4, I'm going to say, here's the physical requirements of the job. I need you here from 8 to 4, Monday through Friday. And if you can't, maybe I need to have that conversation a little bit more. But to me, it doesn't matter if it's an issue of pregnancy, if it's another health condition, if it's a religious objection. It really doesn't matter. All I care about in pre-employment is, can you perform the job or not perform the job? So I think once you start asking questions about, are you pregnant? That triggers liability. Do you have a disability? You're not allowed to ask that in that pre-employment inquiry. There's even restrictions on physical examinations and drug testings and those kind of things pre-offer of employment. So I generally advise people, don't ask and don't assume. And I think where people get in trouble too, and I don't know if it's necessarily pregnancy discrimination, but it certainly can be gender discrimination, is when you start asking people questions like, the women, do you have daycare? Who's going to take care of your children? Again, that's not your business as the employer. All you care about, can the employee be there at those designated times? And if they can, you have to consider them for employment. Now remember, that doesn't mean someone gets a job because they're pregnant or they have a disability or they're in a protected class. It simply means you can't discriminate against that person.
I think that's great advice, and really strong that HR people must acknowledge the fact that although somebody may not be an employee yet, there still are legal ramifications of that employment process that they need to be aware of as they go through it. So really great advice, Rob.
Yeah. And again, the relationship changes, so the conversation changes over time.
Absolutely. So what about the Age Discrimination Employment Act?
Yeah, I missed the days where I didn't have protection under the act, but now I do. Age discrimination protects people 40 years of age and older. And I joke with my students and tell them, don't embarrass me or them by going out and saying, I was 23 and you hired a 21-year-old. That's age discrimination. It may be, but it is simply not actionable. And again, I think this is part of that. We trace the history. This was passed in the late 60s. That civil rights movement was going into play. And I think we were trying to protect workers also at this point in time. 60s and 70s, kind of a turbulent time in the economy. We've seen things like ERISA get passed in the 1970s, where I think there was a concern about maybe some of the abuse and mistreatment of older workers at that point in time. So what the Age Discrimination in Employment Act does, it provides a level of protection. Now, what you have to show to bring a claim for age discrimination is that someone's in a protected class, which means, of course, they're at least 40 years of age, and they suffered an adverse employment action, which is a fancy way for saying something bad happened to them. So if they get fired, if they don't get a promotion, if they don't get hired, or if people make inappropriate comments to them about their age in the workplace, that may trigger some liability under age discrimination in employment. So to prove a prima facie case, all you've got to show is the person's at least 40 and something bad happened to them. So I always tell students, don't rush out of the room and go to law school and think that's easy. Who can't win that case? All that does is get you in the door. Once you show the person's at least 40, suffered the adverse employment action, the burden shifts to the employer, and the employer has to show a legitimate non-discriminatory business reason. So what might be a legitimate non-discriminatory business reason that I, age 40 or above, didn't get a job? Maybe there's a younger applicant, but maybe they're more qualified. Maybe they have an advanced degree that I don't have, or maybe they have more experience that I don't have. There might be reasons that I didn't get a promotion and someone younger than myself did. If that's the case, that's not age discrimination. If the company terminates one person and they say we terminated the employee who was the least in sales last year, and it happens to be the employee who was oldest, that's based on sales. That's not based on age discrimination. So if the employer can show some legitimate non-discriminatory business reason, and they always can, because employers are smart, business people are smart, and they can find something, then the burden shifts back to the employee and they have to prove pretext, which is a really fancy way of saying they're lying. They're telling you this, but it's not true. So maybe through the discovery process, I subpoena the sales records and I find out that you said I was the worst in sales, but actually I was the best in sales. If I can prove that, I may be successful in that case, but it's incredibly difficult to prove. I've had a couple of these cases. They're very tough when you talk about age discrimination cases.
That's great. Thank you very much for that, Rob. Really insightful. From my perspective, I think this next one that we're going to delve into a little bit deeper here, I think for me seems to be the hardest and trickiest for employers to comply with. And I think there are a few reasons why. I like the analogy that you use often about the 50 shades of gray. And it feels like there is a lot of gray that's in this Americans with Disabilities Act, and a lot of terminology and phraseology and legal terms that are thrown in there that I think employers sometimes get a little bit confused with. So I'd like to talk a little bit with you about the ADA and what its purpose was, and when it was rolled out in '90, what you really felt like the government was trying to achieve through this.
Yeah, and again, I think it's just that evolution of providing protection to people who historically may have been discriminated against in society. So I think on this slide you have the major, the major points of the actual law, but there's a lot that you have to look at within those major points. So when you talk about something like a physical or mental impairment that substantially limits one or more major life activities, that's where lawyers get paid to say, what does that mean? And how much of an impairment do you have to have before it's substantial? And what was happening in the 1990s and the early 2000s, courts started really saying substantial means substantial. Like you have to be very limited. And there were a couple of famous cases that came along. In one case, there were some women that applied for a job at an airline. They didn't have 20/20 vision. They said they were had suffered from a disability. The court said, it's one job at one company. You don't have a disability. Another person claimed that they had a couple of health conditions, things like carpal tunnel, things like that. The court said, can you brush your teeth? Can you comb your hair? Can you wave goodbye? You don't have a disability. You can function in life. So when the amendments came in, what Congress was saying is, look, you're setting the bar too high. We want to show that people have the disability. We're not trying to eliminate people from any consideration of employment. So the bar was lowered significantly at that point in time. There was also a split in the jurisdictions about how should you view somebody. If I'm wearing my glasses, then I can see fine. But if I take them off, do I have a disability? And that's what some courts would say. You look at the person with the assistance of whatever that aid is, and some jurisdictions said you didn't. And under the amendments now, we say you look at the person as if they don't have any sort of mitigating circumstances or any sort of assistance from medical devices or those kind of things. The crux of that means more people are going to qualify as having a disability. The amendments also expanded what those major life activities are. One really interesting thing to me about the ADA also is that prong that says if you're regarded as having a disability, which means you don't technically have to have a disability. You could be treated as if you had a disability. And I think why that came into play in the early 1990s, there were a lot of stories, a lot of issues of people that had afflictions of something like AIDS, where a person would go to a job interview and they didn't have any sort of affliction, but they would say, but someone you know does, so we don't want to hire you. And even though the person didn't have a health condition, they were unfairly discriminated against and treated as if they did. So I think that was an attempt for the courts to say, if you have the disability or people treat you like you have the disability, there's potential liability there for the employer. So an employer's obligation under the ADA is to make a reasonable accommodation, not a perfect accommodation, maybe not even the accommodation that the employee wants, but there should be an interactive process that takes place where the employer talks to the employee to say, what is the situation? What's going on? What can we do? And really make an effort to help. If they can't do what the request is, it could be what's called an undue hardship, where maybe it's going to cost too much money, wreak havoc in the workplace, just be an overly burdensome sort of activity that the employer would have to do. Now, obviously, I don't think you can draw a bright line in the standard and say, well, $1 million is too much or not enough, because it might matter on who the company is. What a big company like Amazon can afford is going to be very, very different than some small mom and pop shop. So it's a very fact intensive sort of an analysis, but I think for compliance purposes, courts assume that companies have HR departments, and those HR departments are deemed to be experts. Employees don't know what the rules are. They're going to come to you and say, I'm sick, or someone's sick, or something's happening. The company is the one who's supposed to explain the rights and make sure the employee's taken care of. And I think there's a couple of reasons that organizations want to do that, even above and beyond the law. One, I think the humanitarian thing is you want to treat your employees right, make sure they're taken care of, that they're okay. The other part of that's the administrative side. We do want to be in legal compliance with these things. So I think it's kind of a two-pronged approach, but there's a lot of potential pitfalls with the ADA, and amendments only came about 10 years ago, and a big part of my dissertation was the ADA amendment. So I spent way more time than we could ever talk about in this lecture talking about that. But there was palpable fear in higher education when these amendments were coming into place. And I think we're just now starting to see the waves of cases that are being impacted by that. But it's certainly something that employers want to pay attention to. And to your point earlier, Ken, I think one of the important things that students have to realize, these laws do not operate in a vacuum. The ADA, the FMLA, pregnancy discrimination, gender discrimination, all this stuff fits together. And truthfully, if I'm handling a case as a plaintiff's attorney, I may be bringing claims on 4, 5, 10 different laws that I could say were violated. So it's important that I think every student at least knows the basics of all of these and can at least identify and spot some potential pitfalls down the line.
And that was one of the points of clarification I was going to ask you to make there, Rob, is just really how this ADA does sit in the center of a lot of these other laws, not just anti-discrimination laws, but benefit programs as well. So whether it's short-term disability or family medical leave, your unpaid time away from work, where your job's protected, or workers' compensation, ADA really wraps itself sort of around all of that, I would say, from a protective standpoint, to make sure that the individual is protected. Would you agree with that?
100%. And I think the thing too is, as an employer, you have to comply with all of these. So, if you've got policies that say, under the FMLA, hey, at the end of 12 weeks, you're fired, you're out, and you're not doing an ADA analysis at the end of that, or you're in a state that may give greater rights than 12 weeks, you're really creating a lot of liability for yourself. So I know it can seem confusing, and it is kind of these esoteric sort of laws and things, but Just because it's difficult does not give you the excuse to ignore it, and certainly employers have to comply with it. So I think your students knowing the basics will serve them well. I used to teach a labor relations course, and I would tell students in there, you may or may not negotiate a collective bargaining agreement someday. I would tell every one of your students, if they're a management major, I promise you, you're going to deal with these issues probably almost every day, but certainly very frequently. Someone's going to come in and say, I'm sick, I'm pregnant, something's going on that requires me to take leave. So knowing the basics and keeping yourself out of trouble is going to be a real benefit to you in your career.
Yeah, tremendous advice, and I can attest to the fact that you hear it on a daily basis for sure.
Yeah, maybe an hourly basis in some situations.
Unquestionably, yeah. So Rob, I think for those individuals maybe that haven't worked in human resources so much in the past, or maybe they're new in the workforce, they may not be as familiar with the Equal Employment Opportunity Commission. Could you just talk a little bit about the agency and what its job is in terms of?
Yeah, I mean, I've actually filed EEOC complaints, defended them for employers. So I've been through the process multiple times. But essentially what the EEOC does, it is a prerequisite. It's an administrative remedy before you can run into federal court. Judges, to me, they're nice people, they're smart people, but they're busy people, and they've got a docket of cases, and they don't want to hear your case unless they have to. So the first place you have to go is to the EEOC. Now, normally, depending on what state you're in, you're going to have between 180 to 300 days to file a complaint with the EEOC. Many states, for example, I'm in Ohio. Ohio has the Ohio Civil Rights Commission. They have a mirror organization. So you can file a complaint at the Ohio Civil Rights Commission and or the EEOC at the same time. Whichever one you file in, they will say, do you want to file in the other one too? And you always say yes, but only one's going to investigate that claim. But if we go to the EEOC, if you're the employer defending, the first thing you want to look at is the calendar. And you're going to say, did they file this within that 180 or 300 days, depending on what state you're in? And if they didn't file that in a timely manner, one way to save yourself a lot of time and money is simply say, it wasn't filed timely, this thing's stale, you shouldn't even look at it. But if you don't do that and you send them information or talk to them without that kind of a defense, you may waive your right at that point in time. So what happens is the employee files a charge, that's what we call it, and it's a little complaint. Usually these things are 1 or 2 pages, and they'll say, I have a problem with whatever the organization is, and they will say specifically what the problem is. And there's certain characteristics they have to write in there about the company. How big is the company? How many employees? Because you want to make sure that the law is triggered and the company has the right number of employees. So then you say what happened and what you want the remedy to be. Maybe I want the company to stop doing it. Maybe I want my job back. Probably I want money in this situation. The EEOC then sends that charge to the employer. The employer has 10 days to respond, something you won't find in a textbook, but in real world, the EEOC will give you an extension of time quite often. I always advise people get it in writing, have it faxed and signed from them that yes, we will grant you an extension of time. And sometimes you need that extension of time because you may need to gather documents, talk to witnesses. 10 days isn't a whole lot of time sometimes for a big company or a case involving a lot of witnesses. So you get the charge, you file your response, and most often companies are going to say, there was no violation, we don't know what this person's talking about, we're going to deny everything. Then the EEOC sends out an offer of mediation to the parties. So they will say, you, the claimant, and you, the employer, if you would like to mediate, we're willing to do that for free. I should point out also, it costs $0 for an employee to file a complaint. So sometimes they can do it just to be vindictive. Sometimes they do it just because they want to do something to get back at the employer. But I would say you want to take these claims seriously, regardless of what the basis of the claim is. So if you go to mediation and it gets resolved, that's the end of it. You know, the company does this, the employee does that, everyone goes their own way and things are done. If it doesn't get resolved at mediation, the EEOC will continue their investigation. Now, if you go to mediation, you cannot subpoena the mediator. You cannot subpoena evidence, witnesses. You can't talk about any attempt to settle it at mediation. It's like mediation never happened if it doesn't get resolved there. And I think that's a good thing because we want to encourage people to try to resolve things at mediation. And if you think things are going to come back to haunt you, then obviously you're not going to be as forthcoming in that situation. But the EEOC will then continue the investigation if we don't resolve it at mediation. And at the end of that, they will issue a ruling, and they will say either we find cause, which means we think there's a violation, or we find no cause, which means we're not saying that something wrong didn't happen. We're just saying we simply don't have enough here to prove it on the evidence that we have. So if they do find cause, they will give a recommended settlement to the employer. They'll say, we think you should pay X amount of dollars. The employer is not legally obligated to do that. If the employer settles it, case is over, it's done, things are finished. If the employer doesn't settle it, the employee has 90 days to file a lawsuit. The EEOC will issue what's called a 90-day right to sue letter. You have 90 days then to take that letter, go into court, file your lawsuit against the employer. So courts are going to make sure that you filed that. At that point in time, it goes into litigation. Now, in some cases, if the EEOC finds conduct egregious enough, they can actually file a lawsuit themselves on the part of the employee. So I would tell an employer, the overwhelming majority of time, the EEOC says no cause. We just don't know. If they say there's cause, then they probably think there's a pretty significant violation. And I think employers have to take that incredibly seriously, because if they're finding it and it goes in front of a jury, you've got a lot of added expenses, because when you talk about these types of cases, it isn't just the damages, it's the court costs, the legal fees. They could add up into tens of thousands of dollars at the end of the day. So, if you can avoid paying that, you're kind of smart to do that. The EEOC, in my experience of dealing with them, though, they've always been very helpful, no matter which side it was on, plaintiff or defendant. The mediation aspect of that, I always encourage people to engage in that for a couple of reasons. Part of it is an attempt to settle it. I think sometimes textbooks act like mediation, or mediation especially, is a panacea. It settles all these things. In my experience, maybe 25 to 1/3% of the time it might work. But seriously, if you can get rid of a quarter of your problems by having a conversation, that's a good thing. But I think the tactical part of why you want to go to mediation through the EEOC is you get a good look at the person across the table. And if the company comes across as cold, uncaring, I want to put that in front of a jury. If the employee comes across as greedy and a bad person, I don't mind a jury seeing that either. But I also want to know if that isn't the case. So it gives you a really good preview of exactly what litigation is going to look like if it goes further. I also encourage students to go to the EEOC website and pay attention to what's going on there. They have a great news section. They also have a lot of resources that people can review. The Code of Federal Regulations, things are published there before they go into the EEOC regs. Now, the EEOC does not have the power of self-enforcement, meaning they can't put you in jail and do bad things and make you listen to them. But courts give them great deference. So if something goes to trial, a court may look at EEOC regs and say, even though this isn't technically a law, these people are the HR experts. And if they say it, that's the way we think things should be. So, as a business person, I would really encourage you, watch the news section, see what people are doing, but also look at those resources that they have on there. They're really worth a periodic review. The news section will shock you, because you will see big employers doing things that you just can't believe people are doing in this day and age. And I always tell people, smart people, they learn from their mistakes. Really smart people learn from the mistakes of others. So as you kind of watch what these companies are doing, it can clearly show you how not to run your business and how not to make decisions too sometimes.
Rob, that's extremely helpful. And I pulled up on the final slide here, the newsroom website, for those people that might have an interest in going out there and looking at that for sure. We're going to be covering the Department of Labor in an upcoming session and going through the Family and Medical Leave Act and some of the other pieces of legislation that the DOL is responsible for. But I would just say thank you on behalf of the entire class. I found this very informative myself. I really appreciate the time that you've given us today, and really hopefully the class has really gotten some great information here. I'm sure that they have, and just want to, on their behalf, want to thank you as well for your time.
Yeah, I'm glad to help out anyway, and your class is in very great hands with you there. And, obviously you've got a lot of experience and a lot of background in these kind of things. So I'm sure they're learning a lot. And again, I would tell them this is stuff you're going to use well beyond this course. So put the time in, learn it. This is not something that you're going to want to forget about.
Awesome. Thank you so much, Dr. McDonald.
Take care.
Bye.